Welcome back to Lost Dash Channel. My name is Anton Vieltsin. I'm an attorney in the Southern District of California here in San Diego. Today we're going to discuss a case where police officers pull over a vehicle and they see in plain view a small container of marijuana, which is legal under California state law. Yet they use that information to establish probable cause to search the entire vehicle. So the question, of course, whether state police officers can use federal law to establish probable cause. And before we go on, I want to thank you for watching me on YouTube. If you're listening to the podcast version of this recording, please give it a 5-star review rating. And finally, if you want to support my channel, go on my website at lostdash.com and check out some of the merch. I have these Do Not Arrest This Person t-shirts, hats, and other items. Thanks for watching.
Quick message from Lost Dash. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vieltsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the Lost Dash YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the Lost Dash YouTube page. That's L-A-W-S-T-A-C-H-E.
Today we're discussing United States versus Talley, who was pulled over by the San Francisco Police Department for violating traffic law, specifically for driving in a lane reserved for buses and taxis. Now, Mr. Talley doesn't say that this initial encounter is illegal. Instead, he says that what followed violated his Fourth Amendment rights. Here's what happened. When the officers pulled him over, one of the officers observed a pill bottle, one that you have to squeeze on the sides in order to open the top, in the middle console. Now, this pill bottle was clear, and the officer could see that inside was a small amount of marijuana. Now, using that information, the officer believed that he had probable cause to search the entire vehicle. Mr. Talley gave the bottle for inspection to the officer, and the officer then instructed the second officer to conduct the search of the entire vehicle. They found a firearm and some ammunition in the vehicle. Now, Mr. Talley was a felon, so he was not supposed to have any firearms. He was charged with 922G, which is a federal statute that prohibits felons to possess firearms. Mr. Talley argues that his Fourth Amendment rights were violated because the pill bottle did not give probable cause to the officers to search the vehicle. So remember, the Fourth Amendment protects you against unreasonable searches and seizures, and generally speaking, officers need to have a warrant before they conduct a search. In fact, the Supreme Court repeatedly said that searches conducted without a warrant are per se unreasonable under the Fourth Amendment, and they're subject only to a few articulated exceptions to the Fourth Amendment requirement, the warrant requirement. One of those exceptions is the automobile exception, which allows officers to search the vehicle if they have probable cause to believe that the vehicle contains contraband. And of course, if the officers violate the Fourth Amendment, we have what's called fruits of the poisonous tree doctrine, meaning that anything that follows an illegal search will be suppressed and cannot be used against the individual in trial. So let's go ahead and first look at the marijuana laws in California. After Proposition 64, some possession of marijuana is now legal. So let's look specifically in detail at this statute. Proposition 64, passed in November 2016, decriminalized the possession of 28.5 grams of marijuana or less by persons aged 21 and over in the state of California. Furthermore, Proposition 64 provides that cannabis and cannabis products deemed lawful by this section are not contraband, nor subject to seizure, and no conduct deemed lawful by this section shall constitute the basis for detention, search, or arrest. In the context of operating a motor vehicle, the statute Vehicular Code 23222 states that while driving a motor vehicle, it is an infraction to possess any receptacle containing any cannabis which has been opened or has a seal broken, or loose cannabis flower not in a container. In this case, the federal court relies on the state appellate court decision, which stated that transportation of small amounts of marijuana in a plastic small container that looks like a pill bottle, where you have to squeeze the sides in order to flex the top to open it, did not violate state law. And in fact, the officers believe is mistaken where they think that the container must be vacuum sealed. In this situation, the transportation of the small amount of marijuana, under 28.5 grams, was perfectly legal for Mr. Talley, and thus did not provide probable cause to search the entire vehicle, just like the statute says. In fact, Proposition 64 explicitly states that possession of this small amount of marijuana should not be the reason to search, arrest, and so on. But now let's take a look at federal law. The government relies on the fact that under federal law, any possession of marijuana is still illegal. The Ninth Circuit has repeatedly declined to decide the question whether state law enforcement officers can rely on federal law in order to support probable cause. But here's what the district court says in this case. Federal law cannot provide an alternative basis for probable cause. To hold otherwise would allow officers to disregard entirely the California legislature's directive that no conduct deemed lawful by this section shall constitute the basis for detention, search, or arrest. Indeed, it would lead the paradoxical result of allowing state law enforcement officers to defy the state laws they're entrusted with upholding, so that they might enforce federal laws which they cannot be compelled to enforce. Because the pill bottle did not provide probable cause for the officers to search the vehicle, the district court says this was an illegal search under the Fourth Amendment. And with a poisonous tree, all evidence found as a result of this illegal activity, meaning the firearm, has to be suppressed and cannot be used against Mr. Talley in court. If you learned something, please click like, subscribe, hit that bell notification button so next time I post, you'll be first to know. And if you're listening to the podcast version of this recording, please give my podcast a 5-star review rating. And finally, if you want to support my channel, go on lawstash.com and take a look at some of the merch. I have these Do Not Arrest This Person t-shirts, hats, and other items. Thanks for watching.